act as an advocate of the public's right to oversee government through Florida's public records law and its open meetings law. The purpose of open government rights is to allow the public an opportunity to oversee its government and hold it accountable. So protecting access, the public's right of access to government information, whether that's in the form of records or meetings, is critically important. And that's what we do at the foundation.
How easy or hard is to get the public records?
It depends on what you're trying to get. Florida has a presumption of openness. We presume that a record made or received by a government agency or a government employee is a public record subject to disclosure. And the custodial agency can deny a request only if there is a specific statutory exemption. And the burden is on the agency to tell the requester why he or she can't have the record. Also, under Florida law, if a record contains both exempt and non-exempt information, the agency has to redact or delete that which is exempt and provide access to the remainder. The problem that we've had in recent years has to do actually with access to electronic records. I've been doing this for a very long time, and one would think that once records are computerized and available, and we can send it to you via email as an attachment, that it would be cheaper and easier to get access. In fact, it's becoming harder and more expensive to get access. Partly that's due to the fact that agencies, or maybe in large measure, due to the fact that agencies, when they're digitizing their records and creating these databases, they're not considering public access. And so they're having to go in and redact information from a huge database, whereas if they had considered access, as they're supposed to be doing under the law, if they had considered the fact that the public's going to be wanting access to these records, they can actually create or set up the database and put sensitive or exempt information in certain fields. And simply, give you access to A, B, C, and not D, because D has a social security number in it, which is exempt from disclosure. So it's kind of been a battle. We're having a lot of questions now about access to government email correspondence, text messages. There's a case going on in Orange County right now where county commissioners were texting lobbyists who were opposed to a couple of possible ordinances. Public records requests were made for those text messages, and the county commissioner said, no, well, we didn't know they were public record. We deleted them. You can't have them. And so now there's a case in both civil court and criminal court. Not a case in criminal court. There's a criminal investigation going on.
And what happened when it doesn't happen like that?
Well, there are penalties in the law. An unintentional violation of the public records law is a non-criminal infraction that's punishable by a fine of up to $500. So that would be, you make a public records request for an employee's emails regarding a particular subject. She does a search, she gives you 35 emails, and then finds a 36th. That probably would be unintentional, but that's up for a court to make that determination. Only a court can decide whether there's been a violation of law. Then an intentional violation of law is a first-degree misdemeanor, punishable by a fine of up to $1,000 and a jail term of up to 60 days. But so it's a $500,000 fine. But if you sue a government agency for a violation of the public records law, that agency will be, and you win, that agency will be required to pay your attorney's fees and court costs. So that can be quite expensive. There was a lawsuit filed against the city of Venice and the city commissioners. The case was settled, and it was all about email correspondence between the city commissioners. They were using their private email accounts and their private computers to communicate with one another about city business. Those emails were public record, and the fact that they were communicating via email and having a discussion about public business via email was also a violation of our open meetings law. So in that case, they settled and they agreed to pay attorney's fees, and they were well over $700,000. So a $500 fine or a $1,000 fine if they had gone to court, but $700 and some thousand in attorney's fees and court costs. That's very expensive. And it's important to realize that those are taxpayer dollars. So if our city commission violates the public records law and they get sued, we end up paying for it. So that's a critically, and it's only half the cost, remember, because they have to pay their attorneys. And frequently when this happens, they'll go and ask that their attorney's fees be reimbursed, even when they've agreed they violated the law. Now, under Florida law, there's no agency responsible for enforcing the public records law. So if you, for example, you're having this issue with a state agency and they just are recalcitrant and won't comply, your only option is to go to court. And that's very expensive. And I'm hoping that the legislature will address this problem and fix our public records law so there's some other enforcement mechanism short of filing suit in civil court.